I need to start this video with a bit of a warning, and that is that if you publish a defamatory statement, that is a publication that has caused or is likely to cause serious harm to the reputation of a prospective claimant, the person against whom this publication is made, you may end up being sued and have to pay tens or even hundreds of thousands of pounds in damages and tens or hundreds of thousands of pounds in costs. If that statement's made about a company, then it would be serious harm in the sense of serious financial loss. And so with that in mind, even if it's in your own personal account, your own personal name, you are not immune to a case brought against you in defamation under the Defamation Act of 2013. And so with all that in mind, a lot of people have asked me about the original underlying case in this latest Tommy Robinson episode. So I'll talk a little bit about that in this video. But first of all, if you do like a very objective, open and honest account of what's going on here, I would really appreciate it if you subscribe to my channel. About 60% of the people that regularly watch don't do so, and I'd be really grateful if you did. But equally, the very, very few people that leave rude and derogatory comments will be immediately blocked because I have a zero tolerance approach to that. I don't block or remove people for making questions and comments that you might disagree with necessarily, but if they're rude, I have a zero tolerance to it. So I'd appreciate a cooperation on both fronts. Subscribe if you like the content. Don't leave negative comments because you'll just get blocked. And one final thing that I have to make absolutely clear is that I am just referring to what's in this judgment and the associated meaning judgment. I will link this judgment in the description below. I would encourage you to read it yourself to form your own views and your own judgment. And none of this video of mine is intended to make any statements of fact. I'm simply reviewing what is contained within some, not all, of this judgment. So again, I'll link this in the description below. So as you can see, this HTML version of this judgment is hyperlinked, so you can jump around using these links here to look at various bits. And the first bits that tell you why this case was brought in the first place is A to C. And then we move on to the meaning of what words were actually complained of. So let's go to A first, which talks about the claimant himself and what happened, what was being discussed, and then why this claim was brought. So the claimant in this case, 18 years old at the time of the judgment, came to the UK in 2016, was granted a refugee settlement status under the Syrian Vulnerable Person Resettlement Programme. After arriving in the UK, was enrolled as a pupil at this school in question in 2016. And at that stage, understandably, the judge said his English was assessed to be very poor. Since the trial in May 2021, he'd turned 18, but prior to that point in the litigation, he was represented by a litigation friend. For those of you that don't know what that means, it just means that a child will be assisted by somebody else who is called their litigation friend, which is somebody that essentially helps to conduct the litigation on their behalf. Even if they have solicitors instructed, they will be represented by a litigation friend. Now, this whole case really started with an incident in October 2018 between the claimant and another boy at the school. This incident was filmed, the judge says almost certainly on a mobile phone by another pupil, lasted 38 seconds, and then it essentially went viral and received a lot of media attention. The incident is described in full in section B just here, but in short, this other boy, Bailey, had grabbed this claimant by the throat and forced him to the ground, and whilst on the ground forced water onto him, among other things. You can read the full description here yourself. Now, just as an aside, this Tommy Robinson case and many other cases that have been to court in the last few weeks and months have highlighted just what a devastating impact a court case can have on your life. We've had clients come to our firm that have had their lives turned upside down by identity theft, cases brought against them for debts that they didn't even know existed. And as you know, I partner with companies on occasion to help support my channel, and one such company is Incogni, who helps to prevent you from being the victim of identity theft. Because many of you might not be aware that when you buy things online, or even when you just browse the internet, you're sharing your personal information with various different companies. That then is collected together by data marketing companies that sell on your data to the highest bidder. They put you together together like a jigsaw puzzle, and the more information they have about you, the more valuable that package of information is. The problem with that is not only that you receive lots of junk marketing, but your information might also end up in the wrong hands or even on the dark web, and then you might be the victim of identity theft. Incogni is a straightforward service that when you sign up and create an account, you instruct them to contact all of these data marketing companies and insist and require under UK and US law that they remove your data from their servers. If you do receive any further marketing that's linked back to those companies, you would probably have a claim against them because they should have removed your data. Incogni provides you a dashboard to monitor the progress, and it's saved me countless dozens of hours so far, and I've been monitoring the progress over the last few years using Incogni myself. And as I've said before, I wouldn't recommend something to you that I wouldn't use myself. Of course, as a partner to my channel, you get a fantastic discount, which is 60% off an annual plan using the code BlackBelt with the link on screen and in the description below. So if you want to limit and reduce the risk of being the victim of identity theft, take up this plan with Incogni using my link in the description below. Grab yourself a 60% discount with a 30-day money-back guarantee. You won't regret it, and it'll be a fantastic peace of mind. And it not only helps you, it also helps to support me by supporting my partner for this channel. But it's interesting to note as well that the judge also commented in his final words that had this not been recorded on a mobile phone and later shared on social media, it would have remained a disciplinary issue within the school, dealt with appropriately by the school, and with Bailey receiving a police caution for common assault. The matter would have ended, the judge said. However, once the viral video became the subject of national media coverage, Bailey was portrayed and regarded as a racist bully who carried out a nasty assault on the claimant. I have set out in the judgment the consequences for the claimant, but the impact on Bailey was also immediate and stark. On grounds of physical safety, he and his family were also forced to move from their homes. In that respect, he suffered in the same way the claimant did. Following the defendant's first and second videos, which I'll come back to in a moment, both were schoolboys when they were catapulted into the maelstrom of the media storm. Neither was remotely equipped to deal with what happened. So that incident in October was filmed, the video went viral, lots of media outlets covered it, including then Tommy Robinson, in 2 videos that he posted on Facebook. And it's those 2 videos that form the substance of this case, to say that the content within those videos was defamatory against this claimant who was the subject of this incident in October 2018. So with that in mind, let's first go to the Defamation Act, where this comes from. There is a requirement of serious harm under the Defamation Act. That is, as I've said, a statement is defamatory if, actually it's phrased in the negative, a statement is not defamatory unless its publication has caused or is likely to cause serious harm to the reputation of the claimant. And if it's a company or trade body, serious harm is that in the form of a serious financial loss, or likely to cause serious financial loss. And so how does this come about? Well, when these cases go through court, they have what we know as a meaning hearing. That is, what is the ordinary meaning of the words complained of, and does that amount to a defamatory statement? My learned friend Alan Robertshaw from Art of Law, I'll link in the description below, has got a lot of videos talking about this. He's a specialist in defamation, so go check him out as well. But let's move to the meaning decision in this case against Tommy Robinson. Now, so this was a judgment standing alone by itself, but just looked at the meaning of the words. Now, you may or may not know that all of this started with 2 videos published by Tommy Robinson, the first and the second video they referred to. So all of the wording in the first video culminated to the meaning as follows. The claimant had, 1, as part of a gang, participated in violent assault on a young girl, which had caused her significant injuries, and 2, threatened to stab another child. So just to be clear, that's what the judge said the first video was saying. That was the meaning of the first video. The second video, which the judge said was really a follow-up video to the first to broaden the scope of the discussion, the judge said had the meaning as follows. The claimant had, as part of a gang, participated in a violent assault on a young girl which had caused her significant injuries. And so the judge deciding that that's the meaning of these 2 videos. Now, when it went to trial, the judge was to decide whether there was any defense to making those statements, because by themselves, those had caused or were likely to cause serious harm to the reputation of the claimant in this case. Now, in any such case, one may rely upon a defense if such a defense is available. One such defense is the truth. And if one argues that the statements made, the meaning of those words, as we've just outlined, if it is made out that that was substantially true, it doesn't need to be 100% true and entirely true, just substantially true, then this forms a statutory defence under the Defamation Act 2013. That is, a defence to an action for defamation is to show that the imputation conveyed by the statement, i.e. the ordinary meaning we've just discussed, is substantially true. Another statutory defence might be honest opinion. So, for example, it is my opinion that this guy is rubbish at doing his job. Then so long as you've got some reasonable basis and you can show that other people might come to the same conclusion based on whatever facts and evidence that you've relied upon to give your opinion, then that might apply as a statutory defence. It isn't sufficient, for example, to say, in my opinion, that guy's a fraudster, if there is no reasonable basis to draw that conclusion, and no reasonable and honest person would draw the same conclusion, because fraud is quite a serious accusation. On the other hand, if someone had been already convicted of fraud and you said, in my opinion, you shouldn't trust that guy because of his background in fraud convictions, that might be a different matter, because then your honest opinion is based on the facts that someone else could rely on to form the same opinion, and then that might form a defence for you. Another defence might be that of publication on a matter of public interest. Now, as we've discussed a number of times on this channel, public interest is not what the public might be interested in. It is something that is in the interests of the public, which is subtly different. So then it would be a defence to a defamation claim to show that whatever statement has been complained of, i.e. the ordinary meaning of those words we've just discussed, formed part of a statement on a matter of public interest, and that the defendant reasonably believed that publishing the statement complained of was in the public interest. So if, for example, this was something published about, let's say, a police officer that looked like they were doing something wrong or bad and needed to be scrutinised, then it is in the public interest, not just of interest to the public, but in the public interest, that this is publicised so that that could be scrutinised and properly adjudicated by the appropriate body, be that the criminal justice system or the IOPC. And so a publication in that sense might be a defence if a defamation claim were brought for something that was of public interest, i.e. in the interests of the public. But let's not get ahead of ourselves. Let's get back to the case. So looking at this case here, this is available publicly and you can read through in full detail. And so I have to say I will link this below. And if you form any views and any opinions, you should read the full judgment and form your own views. And I am not making any statements of fact here. I am going over this judgment and telling you what was said within this judgment. So again, just to repeat that warning at the outset of the video, it would be a further defamation if you were to repeat the defamatory statements as fact rather than in the context of something else. So here, for example, I'm talking about this judgment in an educational context, and for the avoidance of doubt, I am not making these as statements of fact. I am discussing this judgment with you. So again, please don't confuse the two. You cannot repeat those defamatory statements and just say that they're available online somewhere, therefore it's fine. That's not the case. It has to be within a particular context and not as a statement of fact. Anyway, moving to this, let's move first of all straight to the defense, because I've talked about what the meaning hearing said the meaning of those words were. Now let's move to, again, as I said, there's a defense under section 2 of the truth, i.e. that something is substantially true. That is at paragraphs 32 to 36 of the judgment here. And the judge outlines that it is an old common law defence which is now codified and been replaced by Section 2 of the Defamation Act 2013 that shows that it's a defence to this action if the statement complained of is substantially true. And so then we have this list of alleged incidents that Tommy Robinson relied upon in his defence of the truth. Now, it's worth bearing in mind at this point that when one puts forward a defence such as this and sets out a series of different incidents, one will have to bring evidence to support those. Now, Tommy Robinson didn't give evidence himself. Rather, there was hearsay evidence, that is evidence of someone who is not in court giving that evidence, on which less weight will be placed. And other witnesses that did come to court did give evidence and were cross-examined. Now, the way that the judge will decide these things is in a number of different ways. First of all, the credibility. First and foremost, the credibility of the witness. And that might mean if the witness will change their evidence when pressed, when challenged on certain parts of their evidence. Whether that evidence is corroborated by other evidence, usually documentary evidence, reports and things like that. For example, school reports, reports to the police and so on. If someone is injured, reports at a hospital of those injuries being treated and so on. And so all of that evidence given by witnesses will be assessed in terms of its credibility and whether it can be relied upon as evidence to support what is alleged to have happened. If the judge does not find that that evidence supports what is alleged to have happened, the judge cannot accept it. Now, that is not to say that if other evidence was provided or the evidence was more coherent, that the judge may have found that these did actually take place. But in the scenario where the judge does not find a witness credible because they've either changed their account or in some cases, as you'll see in a moment, their account just simply doesn't support what is alleged to have happened, then the judge will not find that that evidence supports these allegations. So moving to some of these allegations now, I'm not going to go through them all in a great amount of detail, but I will give you some examples as to why the judge found that these alleged incidents did not support the defence of the truth in this case. Moving first of all to this allegation of bullying by BWI. Children are often referred to by their initials by the claimant. So an alleged bullying by the claimant of BWI. This particular incident whereby the claimant had fractured his wrist. The claimant's evidence about this, at paragraph 58, was that he'd been going to the library with a friend when they came across Bailey and other members of his group of friends. With them was BWI, who was a few years younger. He claimed that Bailey had given BWI a bottle of water, and BWI had then thrown the water in the faces of the claimant and his friend. The claimant said that he gave his school bag to his friend and then chased after BWI to get the water and ask why he'd done it. He seized the water bottle and threw it to the ground. The claimant was then grabbed by the other boys who held his arms behind his back and encouraged BWI to fight him whilst he was being restrained. The claimant struggled but could not release his arms. He alleged that BWI had tried to grab his throat. The claimant was released and then another boy pushed him to the ground. As a result of the fall, he fractured his arm. The claimant denied having put BWI in a headlock. When cross-examined by the defendant, Tommy Robinson, the claimant maintained his account. He added that BWI had been swearing and kicking during the incident. Now, BWI also gave evidence about this. His account in his witness statement, the judge said, was short. In the viral video, Jamal, the claimant, could be seen wearing a plaster cast on his arm, and it was widely said that this was a result of bullying. I wish to point out that this was not the case. That happened after a confrontation between myself and Jamal when he'd been calling my mum names. When he said that about my mum, I went up to him even though he was 3 years older than me. I was angry what he'd called her and threw a plastic bottle at him. Jamal grabbed me and put me in a headlock and was really hurting me. Lots of people saw it. One boy stopped Jamal by pushing him off. He fell awkwardly and hurt his arm on the ground. That was why he was wearing a plaster cast, not because he was bullied, because he was bullying me. The judge said BWI did not claim that this incident was part of any campaign of bullying by the claimant. In a witness statement to support this, another child, OTP, stated that he witnessed this incident between BWI and this claimant. He says in his witness statement, on another occasion, Jamal was grabbing a much younger kid from about year 7, and Jamal was in year 11. He put this kid in a headlock, and a friend of mine went over and threw Jamal off him, just as anyone would, breaking up a fight. Except this wasn't a fight, this was a one-sided brawl, he said. This kid was not a match against Jamal. He didn't come up to Jamal's shoulder. My friend pushed him off the boy and Jamal fell against the curb and hurt his arm. But when cross-examined about this, OTP stated that he was at the top of the field when the incident started, sitting on a bench on the other side of the road, and was quite a way away. He said that his recollection was a bit hazy and that his attention had been drawn to what was going on when he heard BWI shouting and that he went over to see what was going on, a point he'd not included in his witness statement. He claimed to have seen the claimant's arms flailing. Asked why that detail was not included in his witness statement, he said he was not sure whether they'd made contact, so that's why it was not included. And so there you can see, first, that BWI did not claim that this incident was part of a campaign of bullying by the claimant here. But secondly, you can see that when cross-examined, OTP said not only that he was quite far away, that his memory was a bit hazy, but also didn't include details in his witness statement because he wasn't really sure whether they'd actually made any contact, and that's why it wasn't included. And so you can see on the one hand, one version of events tells you one thing, but when cross-examined and a witness gives you a very either hazy or inconsistent account, or just doesn't include those details because they weren't really sure what happened, that is what can lead to a lack of credibility in these allegations. And therefore the judge concluded at paragraph 67, the defendant, Tommy Robinson, contends that this incident shows that the claimant had a propensity to use violence and is a bully. The incident that we're talking about here by itself for a moment. The judge says, in my judgment, it doesn't establish either. BWI did not claim in his evidence that he was bullied by the claimant, and the defendant's not demonstrated that in this incident, the alleged headlock, the claimant was the aggressor. I think it's more likely than not that he was the victim of violence that was used, and that this was another incident of bullying at the hands of boys older than BWI, but BWI was willing, perhaps to curry favour with the other boys, to involve himself in the incident. So the judge essentially didn't accept on the evidence that was presented that this actually happened in the way that was put forward in support of the defence of the truth here on behalf of Tommy Robinson. The next incident I'll deal with relatively briefly, the claimant's alleged verbal abuse of and towards girls and women. Now, in short, AYQ, another child, was giving evidence here, and the bit that I've highlighted here said that she was walking home from school up towards the shop, Jamal was there and just started calling me names. Now, the emphasis here is where she was. Now, again, when cross-examined, that account changed. When cross-examined, she said the incident she described happened at the back gate of the school. And so the judge didn't accept her evidence. The judge said it is not credible and it's not supported or corroborated by any other evidence. She was inconsistent about the place where the incident happened, whether she'd actually been struck by the claimant, a detail she would not have forgotten. So I very often say if someone is struck with something, they would remember it, they would report it, and there would probably be some documentary evidence about it. The judge said there are no corroborating documents. Given its seriousness, had her mother reported the incident to the school, as claimed, the judge said, I'm satisfied that there would have been a record of a complaint, even were it true that the claimant could not have been disciplined about the incident because it had taken place outside of school. And ignoring her evidence in the witness box that the incident had happened by the back gate of the school, at the very least, as a serious behavioural issue towards a fellow pupil, the claimant would have been challenged about it and the incident recorded by the school. So the judge effectively said, had this really happened, it would have been recorded, something more would have been made about it, even if it was outside of school. The judge said, in summary, had the incident happened and had it been reported to the school as alleged, there would be records. There are none. So this was essentially the judge saying that there were no records of it, therefore the judge didn't accept that it had happened, in addition to the fact that the location had changed when pressed under cross-examination. Now, just moving aside for a moment, I'm sure everybody can remember an incident of being hurt, either you've fallen off a bike or you've been hit with something. I remember some very odd things, falling off a bike and hurting my knee. One day being in Australia, hurting my arm here, and I point to exactly where it hurt, and I know exactly how it hurt, where I was and what happened. And so and that was over 20 years ago. So if I were challenged on that now, my memory would be just as clear now as it was then. And so many people, when pressed, if they do change their account from what has been reduced to writing in their witness statement, a judge is much less likely to take that as credible evidence. So again, that is not to say that these things absolutely did not happen, just that the judge did not accept that they happened based on the evidence before the judge at this trial, when pressed under cross-examination. And if nothing else, that is a lesson to absolutely get your evidence right the first time it comes to court, and it has to be consistent, because if your evidence changes or it is in any way inconsistent, and the judge is less likely to take it as credible evidence. The judge then dealt with similar non-specific allegations that he'd been abusive towards women and girls, included in the witness statements of Bailey, Charlie, and OTP. The judge said is not going to set out this evidence and cannot attach weight to generalised allegations of which cannot be challenged in court because of the lack of detail. The judge said, moreover, I'm satisfied that if the claimant had behaved so repeatedly in the abusive manner alleged, including to members of staff, then this would have been recorded in the claimant's school records. There is no trace of any such behaviour by the claimant in these records. On the contrary, his behavioural record is overwhelmingly positive. Further down, we have a section dealing with whether or not the claimant was sent to isolation as punishment for bad behaviour. It says the defendant, Tommy Robinson, has claimed as part of his case that the claimant's not told the truth about whether he was punished for bad behaviour by being sent to isolation whilst he was at school. His school records do not show, the judge says, that he was ever sent to isolation. The judge says, I've noted that in the claimant's records there are several entries of detention given, pastoral. No attention was paid to these entries during the trial, and I have no evidence or explanation as to what this means. But it is clearly a different response from detention, which appears in the records of other pupils. It also appears that there was a hierarchy of detentions, escalating to senior leadership detention and ultimately head teacher detention. But then it comes to some evidence as to what Tommy Robinson said he relied on in regard to this isolation, detention, and so on. It says the defendant relies upon the evidence of the former teacher who on occasions used to supervise isolation and who told the defendant that the claimant was in isolation loads of times. So this former teacher said that this claimant was in isolation loads of times, even though that the judge said that the claimant's school records do not show that he was ever sent to isolation. It goes on, and the evidence of OTP said in his witness statement claimed that the claimant had been sent to isolation for attacking someone for an unidentified occasion. When he gave evidence at trial, the defendant showed OTP what the former teacher had said and asked whether it was correct and that the claimant had never been in isolation. OT replied that the claimant had been there multiple times with him and the former teacher. In fact, although OTP's school records appear to confirm that OTP had been sanctioned with detention on many occasions, sometimes on a daily basis, there is only one record of OTP being sent to isolation. Further, the judge says the comparison between the records of the claimant and OTP shows that there was not a single occasion when the claimant and OTP attended any form of detention on the same date. Ultimately, the judge says, I reject OTP's evidence and I can place no reliance on the hearsay evidence of the former teacher because the circumstances in which his statement was made and, critically, because his evidence has not been tested by cross-examination by reference to the school records, which appear to contradict the evidence of OTP and the former teacher. So this, again, is a situation where you've got the actual records of the school contradicting the evidence which is in some way contradictory by OTP and the hearsay evidence of the former teacher, each of which was rejected by this judge. The judge said, in summary, the defendants failed to demonstrate that the claimants had any propensity to behave in an aggressive or abusive manner towards girls and women. For the reasons I've given, I'm unable to accept the evidence of AYQ and BWI. But even if I had accepted it, it would not have demonstrated propensity on the part of the claimant to act in this way. The more reliable contemporaneous evidence in the school records provides powerful support for the conclusion that the claimant did not behave in the alleged way. So again, whether you agree with all of this or not, this is what the judge found based on the documentary evidence that was put before the court and testing the evidence of those that did come to court and somewhat discounting the hearsay evidence of those that did not come to court because it was not tested in court against the contemporaneous documentary evidence that was indeed at court. After this, in the judgment, there are a number of different incidents as well, each of which had some contradictions. So very briefly, there was a hockey stick incident which had a number of contradictions in the evidence in the trial. First of all, including when this was said to have happened. Secondly, that the incident had led to the girl in question being off PE for some 3 months, even though when took through in cross-examination, the record of attendance in PE classes said that she'd attended 60 out of 66 lessons, which was again at odds with not having done PE for the 3 months that she said. Furthermore, she said that she was taking pain medication on an ongoing basis and scans and so on for injuries. And yet then again in cross-examination, she was shown a letter from her GP that said that she does not suffer with any current medical problems. Additionally, there was evidence from another child that contradicted himself in a number of ways. First of all, by saying that the teacher was in the storeroom for most of the game, but then contradicted himself when giving an account of as to what order the events took place. And so in the witness statement, saying that the teacher came over and sent the girl off for first aid, but initially in cross-examination had claimed that the teacher only came back towards the end of the lesson. and then went on to claim that the teacher had been in the storeroom for the entire game, and it was only after the lesson had ended that the girl had the opportunity to speak to him. There was also a video recorded interview which was relied upon by hearsay evidence, which again was somewhat contradictory. And again, the judge said that this account was materially different from the account given by the girl and the account given by OTP in the witness statement and evidence in cross-examination. So multiple layers of inconsistency there. Finally, there was another child, Bailey, who also said, we all knew about the time that he hit the girl with the hockey stick because of lots of people saw it. But when cross-examined about it, Bailey then confirmed that he'd not witnessed the incident himself, but had heard about it by a rumour a few days after allegedly it had happened. And so the judge said little, if any, weight can be placed on this evidence, which appeared to have been inserted into his witness statement in an effort to simply bolster the evidence by repetition that these things had happened. And so the judge said, for the reasons that I'll explain, the judge said, I reject the evidence of the girl and OTP and accept the evidence of the claimant. And so ultimately the judge went through each of these incidents, the materially different accounts of what happened, contradictory evidence such as the school records or even lack of records in some cases, and found that these incidents relied upon as the defense of truth just didn't support the defense of truth, and thus the defense failed. And so in a very short and succinct conclusion at paragraph 148, the judge said, for these reasons, the defendant has failed to prove the substantial truth of the imputation 2. In consequence, the defendant's truth defense must be rejected and judgment on the claim will be granted to the claimant. And then the judge went on to look at remedies, which included damages, an injunction, an order under the Defamation Act requiring Tommy Robinson to publish a summary of this judgment. And the injunction is the bit that came about again just recently. The injunction was to not repeat the defamatory statements that he'd made in those original 2 Facebook videos, which resulted in Tommy Robinson being committed to prison for 18 months, of which he will serve half. So I think in my hastily editing yesterday, I inadvertently cut that bit out where he will serve half. Just as I explained, the judge dealt with it as he would any other criminal sanction. So I hope this, albeit fairly swift overview of what is obviously a very lengthy judgment, gives you some idea just as to how evidence can be tested, whether it's direct evidence from witnesses, hearsay evidence from witnesses that do not come to court and do not have their evidence tested, upon which less weight is placed because it's hearsay evidence. They are not in court to have their evidence tested. Importantly, their evidence is not tested against contemporaneous records. So, for example, what the former teacher, by way of example, made a statement, but in hearsay evidence and was not tested in court. So there was no opportunity for anyone to say, well, here's what the documentary evidence says. What do you have to say about that? You know, you say that this child was in isolation a number of times or lots of times, etc. But the documentary evidence of the school does not support that. The documentary evidence contradicts that evidence. And so if someone is not in court to have that evidence tested, obviously less weight must be placed upon it. And in any event, it was contradictory. And so the judge is very much more likely to prefer documentary evidence because when these things happen, especially if they are serious, they are much more likely to be recorded in a written format, reported to the police and so on. And when it comes to medical evidence supporting injuries, if there are injuries, they are usually documented again by the school records, visiting doctors, records of the dispensation of medication, scans and so on. I can recall cases where there's been some serious allegations of serious harm against an individual, but they haven't brought any medical documentary evidence to court at all. And so that just simply doesn't support those injuries and the allegations that caused those injuries. So again, this is not to say you should absolutely believe everything you read here and everything I tell you. I've just hopefully explained to you why the judge did not find the defense credible in this case by examining the evidence, how some of it was contradictory and how some of it just simply did not support the allegations. So again, I hope that's been useful. Please do leave me some thoughts and comments in the box below. Please do subscribe if you'd like me to go over this sort of stuff. I know it can take some time sometimes to go through these things, and even then I've only really just scratched the surface. So I reiterate, you should read the full judgment in full, not just rely on this video or indeed any other video that you see online to form your views. The full judgment is there for you to read. It is a public document, and so I'll link that in the description below. But in the meantime, thank you for watching, thank you for your attention, and I will see you next time.